lord, this,
95, kind of 80, 90, after 16 years.
Yes, he is writing in response to a question asked by Mr. Sayyid Rafi Raza, who was conducting interviews for this book. Mr. Sharifuddin gave him this signed.
What is the worth of this document?
My lord, only to set the background, nothing else.
It's neither here nor there. It took 16 years for him to write this letter.
It's in similar vein. It is in similar vein.
There, the author judge had said something, so it has direct nexus.
Yes,
but this piece of paper, what is it? Show.
Mercy petition was filed by Begum Bhutto.
Yes, there were two petitions.
If you don't mind, please have a seat. We are hearing amicus, and we will let amicus finish. You can have your say. Please make the old-fashioned way of proceeding was make a point. If you don't agree with anything the amicus says, we'll hear you at your time. Otherwise, we won't make any progress. Tashreef rakhiye Kasuri sahab.
There were a number of mercy petitions, insofar as I am aware.
What is the worth of this piece of paper?
My lord,
16 years after the event, you write, what does it mean? I don't know.
It's probably setting the record straight.
What record?
That when asked by the author of this book in the context of how the sentence was executed.
Still, it doesn't change anything.
It doesn't because it's much after the execution.
Let's forget this. Let's proceed.
So, I was only drawing your lordship's attention that this is probably the only other piece of writing, or you may say, which is on the record of one of the persons involved.
Pizada's conscience did not prick him for 16 years.
And my lord, your lordship also has that video testimony, which will show.
We're going to realm completely sort of.
It only shows that he was pointing out that
if we accept that this has even been written by him, first of all.
Yes.
Then why does he take 16 years to write it? So these are too many ifs and buts here.
The authenticity of this has recently been confirmed in an article written by Mr. Waqar Rana, who had worked with Mr. Pirzada.
You have worked with Mr. Sharifuddin Pirzada.
Yes, my lord.
Did he own up to this thing?
My lord, I am not aware of this. I am not aware of this.
Let's proceed.
So,
Aage badhe.
My lord, yes. My lord, my submission before your lordship is that the 4 questions as framed by your lordship are already on the record. That was a differently constituted bench, but they are part of the order of 12th of December 2023 as well, where your lordships identify these questions. On page 3 of your lordship's order. Your lordship says, paragraph 6, the first and foremost constitutional and legal points, in addition to those recorded in order dated 21st April 2011 that require consideration, are whether the presidential reference is maintainable under Article 186 of the Constitution, whether the presidential reference requires a factual inquiry, and if so, whether under Article 186 of the
Constitution. We know what we've written.
My lord, yes. My lord, my respectful submission before your lordship is that Mr. Zulfikar Bhutto was convicted and sentenced to death in view of the judgment of the Supreme Court in PLD 1979, Supreme Court 38. This, my lord, my submission is that is not to be treated as an ordinary criminal case, because, as I said, it is one of those rarest of rare cases in common law jurisprudence where the sentence having been carried out as a result of a 4-3 conviction, one of the judges in majority thereafter gave a press interview saying that the judgment was obtained under pressure. If that was the case, the principle of nemo iudex in terms of natural justice comes in, and there are 2 situations in which your lordships have said which will unravel any judgment of any court. One is that of fraud, and the other is bias. So if
you applying 12.2 principles?
I am not applying 12.2, I am applying the nemo iudex principle. That if a person is affected by any consideration except the due process of law and the facts before the case, then the principle of nemo judex comes in. This honorable court has...
Now we are going into the merits. We wanted you to attend to the constitutional law of the land first.
This is the constitutional...
This is maintainability.
This is the constitutional submission is based on Article 4 of the Constitution, which I say incorporates the principles of nemo judex.
Can we read Article?
Yes, my lord. To enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen, wherever he may be, and of every other person for the time being within Pakistan. In particular, no action detrimental to the life, liberty, body, reputation, or property of any person shall be taken except in accordance with law. No person shall be prevented from or be hindered in doing that which is not prohibited by law, and no person shall be compelled to do that which the law does not require him to do. I particularly emphasize, my lord, paragraph 1, the first paragraph, to enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen, wherever he may be, and of every other person for the time being within Pakistan. And second, in particular, no action detrimental to the life, liberty, body, reputation, or property of any person shall be taken except in accordance with law. And where therefore any other consideration except due process infects a judgment that, with great respect, cannot be sustained under Article 4 of the Constitution.
Why are you not adding Article 9 also?
My lord, my lord, your lordship is absolutely right. May I point out why I haven't referred to it straight away, and I would refer to 10A, but that came later.
But 10A wasn't there then.
There is reason. If your lordship looks at the language of paragraph 1 of Article 4, to enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen. The Constitution recognizes that this is a right which even precedes the Constitution. This is a right which is not being conferred upon by the Constitution. This is an inalienable right of every citizen. Contrast that, my lord, with the language of Article 8, paragraph 1, which is the Fundamental Rights chapter, and that straight away leads us to Article 9. Any law or custom or usage having the force of law, it talks about shall, so far as inconsistent with the rights conferred by this chapter, shall to the extent of such inconsistency be void. Your lordship is to see the language insofar as it is inconsistent with the rights conferred by this chapter. So over here, your lordship have rights which are conferred by Article 8 and the chapter on fundamental rights of the Constitution. Your lordship must see paragraph 2.
You are saying Article 4 rights are inalienable rights, and Article 10 rights, which are the fundamental rights, are conferred rights.
And
so the inalienable rights take preeminence over conferred rights.
My lord.
Correct?
Correct, my lord. And I say that, my lord, the word conferred is used in paragraph 2 as well. And your lordship will see there too, they talk about, and as your lordship is well aware, that these rights, the fundamental rights, can be suspended under the emergency provisions of the Constitution when an emergency is invoked. And at the time,
Which is that provision?
my lord, the emergency provisions are Article 232 onwards, but if your lordship is looking for
Particular provision.
Article 233, paragraph 1, where certain rights are suspended the moment a proclamation of emergency is made. Nothing contained in Articles 15, 16, 17, 18, 19, and 24 shall, while a proclamation of emergency is enforced, restrict the power of the state as defined in Article 7 to make any law or take any executive action, so on and so forth, my lord. And if your lordship then turns to paragraph 2, while a proclamation of emergency is enforced, the President may by order declare that the right to move any court for the enforcement of such of the fundamental rights conferred by Chapter 1 of Part 2 as may be specified in the order, and any proceeding in any court which is for the enforcement or involves the determination of any question as to the infringement of any of the rights so specified shall remain suspended for the period during which the proclamation is enforced, and any such order may be made in respect of the whole or any part of Pakistan.
Sub-Article 2 only deals with 15, 16, 17, or it encompasses all the fundamental?
My lord, it encompasses all the fundamental rights, because over here, the President may by order declare that the right to move any court for enforcement of such of the fundamental rights conferred by Chapter 1 of Part 2.
Was an order in the field when the trial and the appeal took place?
Yes, my lord.
Which is that order?
My lord, after 5th July 1977, when the proclamation of emergency was made, the Constitution was put in abeyance.
Where can we read that?
My lord, I will find it in a moment and place it before you.
PLD 77.
PLD 77.
आप निकाल दें proclamation of emergency क्या था?
जी sir. और
77 में होगा PLD.
So for one no
Federal statutes.
So for one no order has to be made. Under paragraph 1 no order has to be made. It happens automatically by the operation of law. By the
One doesn't attend to Article 9.
But under 2 an order has to be made.
Bhutto, can I take you back a little?
My lord.
I want to understand, what is the question of law that's been placed before us? Is the question of law to revisit a judgment of this court? Or is the question of law that the judgment has to be revisited for two reasons, because one of the judge made a statement, or because the country was passing through a period of deviation? And would that not entail, is that the question of law?
No, my lord. The second is not the question of law. It's the first which is the question of law. And my submission, based on that first question of law, that Article 4 of the Constitution never having been suspended, and Article 4 of the Constitution, as this Honorable Court notices in the case of Ghulam Mustafa Khar, PLD 1989, Supreme Court, page 26. This was actually even made a part of the PCO, so even the military regime of that time continued with this article and observed that all these requirements will be observed, that in view of that, any order which has been passed in violation of the due process of law can be revisited by this Honorable Court.
You say is because of that interview.
Because of that interview.
So would that not then require a further inquiry into a factual situation as to what the interview was, what did he say, what would the pressure really mean? Are we also supposed, and I want to understand this, that 186 is a question of law, we just answer the question of law as the question of law is? Or are we to investigate further that what is the reason for that question of law, that being an interview according to you? Could we go into the interview? Could we then call people, find out what, could we get into this phase of inquiry to answer the question under Article 186, or is it simply a question of law without an inquiry?
My lord, it is a question of law that if it comes to light that a particular judgment was a result of considerations other than the due process of law, then that judgment by itself becomes questionable.
But this factum that it was otherwise requires inquiry. We can't just simply look at a video and say this happened. What about the other judges? There are a number of judges on the thing. So, I mean, what I want to legally understand is that when we start addressing a question under 186, is it just a legal question, or this might, as in this case, entail looking at evidence and then also the veracity of that evidence, the interpretation of that evidence. Are we going to entail that, get into that exercise also?
My lord, the immediate response will be based on two
Now, I
judgments.
want to add one more thing. That can you point out any specific question that is being posed to us in the reference that is to be answered? Specific question for the Supreme Court.
My lord, this honorable court itself has posed.
No, in reference. In
My
reference,
lord, the reference is before your lordship.
then we should be confined to that question.
My lord, no, your lordship has now framed questions, but if your lordship is looking at the reference on pages 16 to 18, the questions were framed at that time. But may I read those in a minute? They're here. But in order to answer my lord, Mr. Sayyid Mansoor Ali Shah's question, my lord, this arose in the context of an appeal before this honorable court, so the issue was open at that time, and it arose in a context where the proceedings had finally concluding in the House of Lords, as it then was called, in the United Kingdom. In the Pinochet case, the House of Lords, again by a narrow majority, had come to the conclusion that Mr. Pinochet needs to be extradited. An issue arose, and your lordship knows that ordinarily the House of Lords never reviews its judgments. Once they have given a judgment that's final, concluded, and the proceedings were over. But an application was made that Mr. Justice Hoffman, who was one of the members of the majority, his wife was part of the Amnesty International, and Amnesty International had submitted an amicus brief.
That was a review, was it?
My lord, but your lordship knows that unlike in our case in the
That could
Constitution of
certainly
Pakistan,
happen if we were to decide a matter. Somebody could file a review and say that one of the judges had a... So I want to really understand the jurisdiction under 186, that a question of law, as I understand, is that this judgment is wrong. Fair enough. Can we just look at it? Can we then revisit the judgment and say it is wrong, or don't we relying on some extra material now, which you say is the interview, which requires inquiry? Could we just take the interview on the face value, or are we to then find out what the text meant, or are we to, some people need to come forward, do we need to cross-examine, do we need to get into all this, or just take the interview on the face value? And that's just one judge. There are a number of other judges who are not saying anything. Maybe they were not under pressure, or they were, we don't know. So my legal question is, are we to dive into an inquiry? Is that envisaged under 186 is my question.
जैसे जरा सा मैं अपनी तरफ से जरा बात करना चाह रहा हूँ। जो अब आपने बातें की हैं आर्टिकल 4 की, जो आर्टिकल 4 कभी भी खत्म नहीं किया जा सकता है, चाहे 233 के तहत भी नहीं किया जा सकता है। आर्टिकल 9 की एक अलग बहस है, मगर अगर आर्टिकल 4 कभी भी खत्म नहीं किया जा सकता है, तब ये हम बात क्यों नहीं कर सकते हैं, इस केस को अलग रखें, मगर हर क्रिमिनल केस में जहाँ के प्रोसिक्यूशन में एलिमेंट ऑफ पॉलिटिक्स इन्वॉल्व हो जाए, नेचुरली एक वक्त में जबकि आइन सस्पेंड हुआ है या एब्रोगेट हुआ है, तो हर को क्यों नहीं राइट मिले दोबारा अदालत का रुख करने के लिए कि जी आर्टिकल 4 तो आपने नजरअंदाज ही कर दिया, तो आपने कहा कि सिर्फ और सिर्फ ये हम इस केस को देख सकते हैं, हम सारे ऐसे केसेस को क्यों ना देखें? ठीक है, वहां मगर आर्टिकल 4 को देखने के लिए कि दरवाजा खुलता है या नहीं, मेरे हिसाब से आपको केस में जाना पड़ेगा। आप सिर्फ ये कह सकते हैं तो नहीं है कि जी क्योंकि उस जमाने में माशाअल्लाह लगा हुआ था तो फलां शख्स को फांसी हो गई तो ये अनकॉन्स्टिट्यूशनल हो गया। नहीं, आपको थोड़ा सा और मेहनत करना होगी कि आर्टिकल 4 का तो आपको दरवाजा है, मगर आर्टिकल 4 के दरवाजे को खोलने के लिए आपको कुछ हमें बुनियादी चीजें दिखाना होंगी। ये जरूरी नहीं कि इसी केस में हो, दूसरे केस में भी हो सकता है, मगर वो अब देखेंगे अगर सदर साहब मुनासिब समझें कि वहां भी रेफरेंस भेजें, क्योंकि रिव्यू का जुरिसडिक्शन खत्म हो गया तो फैसला तो खत्म हो गया हर लिहाज से, अब रह गया सिर्फ ओपिनियन। तो मैं तो कहूंगा कि अगर आपकी बात को हम आगे ले जाएं और लॉजिकल कंक्लूजन पे ले जाएं तो हर केस में हम कर सकते हैं ये, अगर नंबर 1 वो उस वक्त में कॉन्स्टिट्यूशनल डिपार्चर हो, पहली बात। दूसरी बात ये कि आर्टिकल 4 के आप प्राइमा फेसाई केस आप एस्टेब्लिश कर पाए। तीसरी बात फिर ये होगी कि ठीक है आर्टिकल पहली बात भी हो गई, दूसरी बात भी हो गई, मगर हर केस इस बुनियाद पे नहीं खत्म हो सकता है, उस पर ओपिनियन नहीं दिया जा सकता है, मगर उसमें आपको कुछ मजीद दिखाना होगा। और वो मजीद दिखाने के लिए इस केस में एक जज साहब का इंटरव्यू है, दूसरे केस में शायद कुछ और हो सकता है, क्योंकि डीएनए एविडेंस आ गई हो, फॉर इंस्टेंस कि जो जमाने में डीएनए नहीं होती थी, डीएनए एविडेंस आ गई है। तो ये आप इससे एग्री करेंगे या आप इससे डिसएग्री करेंगे?
My lord, I would most respectfully agree with it, because I would respectfully submit that this is something which is now happening in the other jurisdictions of the world as well. In some cases, it is happening in the context of the state having recognized that in politically charged cases, injustices can take place which need to be corrected, has itself specifically conferred this authority on the courts of law.
That's fair enough. I mean, I'm for fixing miscarriages of justice whenever they happen. It's happened outside another jurisdiction. Miscarriage of justice needs to be fixed. There's no doubt about that. My question right now is the jurisdiction this court enjoys to do that. You know, to understand that. The review is done with, so we don't have any judicial remedy available. So just want to understand whether the window 186 provides is there to fix a miscarriage of justice through an opinion. Is that possible? Because that miscarriage of justice requires probing into the matter, which could be, I mean, you could argue that 186 does include probing into the matter. So that, I want to understand the window, the door that is to be used for the purpose of fixing miscarriage of justice.
If I may just add to my learned brother's thing, I don't think even if we were to come up with a different opinion, there is no question of fixing anything. Now it is only a question of posterity and history. You can't fix anything because the sentence has been carried out. So you can't possibly fix it. So at the moment, all we are faced with is, do you want, as it has been said, do you want this to be used as a precedent in the future? Probably we can give an opinion on that. We can say yes, no, or whatever else we may hear. So fixing part is over. I mean, if the person was alive, that would have been a different scenario. So that scenario is not before us anymore. So even if we were to come to the conclusion that this was miscarriage of justice, we cannot fix it. So the judgment has come, the review has come, that's over. Now we are more concerned with the repute of a person, posterity, history, and whether it constitutes a good precedent for courts to apply. I think probably we can restrict ourselves, and that's the only thing we can really do.
My lord,
Mr. Mahdou, let me add to that also, because there's another question that arises in this.
My lord.
The sole plank on which this case rests is that at that time the judiciary was not independent. It was under pressure. This is the sole plank. There is no other argument. The argument is you could establish that the judiciary was not independent, this judgment goes. Now, how do we go about establishing that fact? And the exercise involved in establishing that fact requires inquiry into the matter, because there is no other argument. The only argument, Article 4 is violated because judges at that time were not independent, allegedly as said. So how do we entail this, how do you get into this exercise that the bench was not independent?
my lord, may I?
Let us not generalize the issue of judiciary being not independent at that time. There were honorable judges sitting at the bench at that time. There, the issue is only restricted to one judge who then came out and he made a statement. So let's not generalize and
If that is the case, that if it's only one judge, then the question is, how does that matter if the rest of the judges we have know nothing on? So how many judges are we talking about? If one judge went astray, then what
I
is
think
happening?
one judge would.
That too requires some inquiry, whether to all this pressure, what does it really mean by this pressure?
Khan Sahab, देखिए, if it was unanimous court or a larger court, one judge would not matter. But if it is the judgment of acquittal and conviction stood on one judge, then I think one judge would matter. And this does not suggest that the other judges were not independent. Let's assume they were all independent, but one judge has categorically come forward and said something. Now, we don't need to enter into the realm of was this actually in an interview, because long after the interview came, broadcast on public national television, he could have said, this interview is doctored, this is not my interview, this is not me, my picture was put, or whatever. That has not happened. And he survived a great number of years after that. So one judge, I think, does matter in this case. There may be other cases, okay, you'll say, okay, one more vote goes out, what difference it would make? Nothing. But here it hung by a thread of one vote. It did matter, I think. That's, if it was 4, it would have gone the other way, acquittal, as simple as that.
My
I
lord,
can't see any other result.
my lord, there have been a number of questions by your lordships. May I?
Can we at this juncture see the thing now, because
Yes, Your
I believe it's ready, or you want to continue
I
with
just
your
want
thought?
to- my lord, no, I'll answer your lordship's questions. I have noted them all down. After that, if your lordship so pleases. Or now, as your lordship pleases.
लगा दें? वो बड़ी स्क्रीन पे नहीं लग रहा है? You'll have to make do with the smaller screen. Can you just turn one a bit that way so everybody can see it? We can see the one and you can volume दे दें.
काफी बड़ा इंटरव्यू सर।
इसको पैदा हुए चीफ जस्टिस सुप्रीम कोर्ट ऑफ पाकिस्तान 26 अप्रैल 1993 को हुए और 14 अप्रैल 1994 को रिटायर हुए। अप्रैल का महीना डॉक्टर साहब की जिंदगी में बड़ी अहमियत का शामिल है। डॉक्टर साहब से हम गुफ्तगू करते हैं।
और तेज हो सकता है
कि हाई कोर्ट के बैरूनी जो दीवार है, लोग उसके साथ गुजरते हुए भी बड़े एहतियात से गुजरते थे कि अंदर जज बैठे हैं, अंदर बड़े लोग बैठे हैं, वो लोग बैठे हैं जो बड़े फैसले करने वाले हैं। और आज उसी बिल्डिंग में गेट से एक आदमी मोटरसाइकिल पे दाखिल होता है, हॉर्न बजाता हुआ दूसरे गेट से निकल जाता है। तो ये जो सूरत हाल पैदा हुई, ये क्या है?
ये तो मेरे ख्याल में आजकल का जमाना है जिसमें कोई किसी की भी ज्यादा रिस्पेक्ट नहीं है। बाकी जज तो वही है बेचारे, उसी तरह मेहनत कर रहे हैं, उसी तरह का ईमानदारी से ही काम करते हैं, लेकिन लोगों को उनके बारे में कुछ शुबात हैं, शकूक हैं, हालांकि मेरे ख्याल में जस्टिफाइड नहीं है। तो बाकी ये जो आप कहते हैं कि वो एहतराम इतना नहीं रहा, ये तो मेरे ख्याल में ये सोसाइटी में सारे महकमों में, सारे अदालों में, हर जगह बस लोग जो हैं वो बहुत ही मादर पिदर आज़ाद हो गए हैं।
लोगों का ये ख्याल क्यों हो गया है कि उनको इंसाफ नहीं मिल रहा? किसी सतह पर लोगों को अगर इंसाफ नहीं मिलने का ये तासर है, तो क्या इस तासर को खत्म करना जुडिशरी का काम नहीं?
यह काम तो जुडिशरी का है, मगर वो मुझे समझ नहीं आता कैसे करें। ईमानदारी से काम कर रहे हैं, मेहनत से काम कर रहे हैं, सही काम कर रहे हैं, तो फिर भी तासुर रहता है। ये ज्यादा सियासी मुकदमात की वजह से है। जब वो कोई ऐसा केस आ जाता है जिसमें गवर्नमेंट इन्वॉल्व होती है या असेंबली को तोड़ दी जाती है या कोई प्राइम मिनिस्टर के खिलाफ कोई एक्शन होता है, तो वो उन मामलात में शायद जुडिशरी ने उतनी तनदही और उतनी इंडिपेंडेंस से शायद काम नहीं लिया जितना के लोगों के तवक्कुआत थी। उसकी वजह से ये मेरे ख्याल में ये ज्यादा इम्प्रेशन हुआ है।
सब ये कितनी, क्या आप इसको अफसोसनाक बात नहीं समझते कि लोग कहते हैं कि वकील की बजाय जज कर लिया जाए?
नहीं, ये तो लोग तो कहते हैं, मगर मेरे ख्याल में ये ज्यादती है और ये बिल्कुल गलत बात है। जजेस अभी भी मेहनत से काम कर रहे हैं, अभी भी वो बिल्कुल सही फैसले करने की कोशिश करते हैं। अब लोगों को तो कोई रोक नहीं सकता, क्योंकि लोग لوگ آج کل بہت ہی جیسے میں نے کہا مادر پدر آزاد ہوئے ہیں. ہر ایک چاہتا ہے کہ فیصلہ اسی کے حق میں ہو. اگر اس کے حق میں نہ ہو وہ سمجھتا ہے کہ جج دوسری طرف ملا ہوا ہے.
عوام سے آپ کیا کہنا پسند کریں گے یہاں پہ کہ وہ کیسے ان کا اعتماد کیسے بحال ہو؟ یہ صرف سیاسی فیصلوں کی بات نہیں ہے. لوگوں کو جب لیٹیگیشن میں جانا پڑتا ہے, جب لوگ کسی ظلم کے خلاف, کسی ناانصافی کے خلاف, کسی غیر قانونی چیز کے خلاف عدالت میں کسی بھی عدالت میں جاتے ہیں اور وہاں پہ وہ اگر پٹیشن دائر کرتے ہیں تو انصاف اس حد تک دیر سے ملتا ہے کہ انصاف کا مقصد ہی ختم ہو جاتا ہے.
یہ تو ہم نے دو باتیں کی. ایک کو ڈیلیز کی بات کی کہ اتنا تاخیر سے ملتا ہے کہ وہ جو ہے اس کا مقصد ہی فوت ہو جاتا ہے. اس میں تو اور عوامل ہیں, مگر یہ کہ ان ججز جو ہے ایمانداری سے کام نہیں کرتے یہ ایک دوسری بات ہے. میں سمجھتا ہوں کہ یہ جو ڈیلیز ہو رہی ہے وہ اس لیے ہے کہ ججز کم ہیں, کام بے شمار ہے. آپ دیکھیں گے ہر ایک ہائی کورٹ کے جج کے پاس تقریباً 40 مقدمے روز ہوتے ہیں. اگر آپ کسی یورپین کنٹری میں جائیں تو 40 مقدمے وہ سارے مہینے میں نہیں طے کرتے.
کس نے روکا ہے کہ ججز نہ زیادہ رکھیں؟ مطلب کوئی ایسی پابندی ہے کہ ججز زیادہ نہ رکھے جائیں؟
نہیں, میرے خیال میں وہ اکنامک حالات ہے نا, یعنی کہ جج کی
ریلیونٹ وہاں سے
بتا سکیں گے
یعنی کافی تنخواہیں بھی کافی ہیں.
وہ منٹس آپ کو پتہ ہے کہاں سے؟
تو بہت ساری باتیں ہو رہی ہیں. ریلیونٹ کتنے دیر بعد آئے گا؟
میں نے آپ سے عرض کیا جو میں نے فائل کی ہے نا,
یعنی کس نمبر پہ آئے گا کچھ آپ کو پتا ہے؟ 5 منٹ بعد, 10 منٹ بعد؟
یہ پوری تو میں نے نہیں دیکھی ہوئی. پوری جو ویڈیو جو ابھی جیو نے دی ہے,
ڈیوریشن بتا دیجیے نا آپ کتنے منٹس کے بعد ہے تو اس کو آگے کر لیتے نا.
جو پورشن آپ کو آپ کے سمجھتے ہیں فیور میں وہ کب آتا ہے آپ کو پتا ہے یا نہیں؟
اس میں نے جو آپ خود فائل کی ہوئی ہے
اس کا بتا دیں.
اس میں مشکل ہوگا مجھے بتانا. سر
آپ کی یو ایس بی میں ہے؟
جی ہاں, جو میری یو ایس بی میں ہے نا, میری یو ایس بی آپ چلا لینا. وہ
پرٹیکولر یو ایس بی ہے سر, اس کو لگوا لیں جو ان کی ہے.
اس کے اندر پرٹیکولر جو میں نے یو ایس بی فائل کی ہوئی
دے دیں, آپ نکال کے دیں یو ایس بی.
میں نے دی ہوئی ہیں سر. کیا کہتے ہیں
یہ ڈائریکٹ ہو جائے گا نا.
Constitution, law and Pakistan affairs must be placed before this court, and that is a book written by him. He has explained all these matters in details, in writing.
Suri sir, we definitely hear you. Abhi we are just trying to.
That book should be placed before all the judges, and
وہ آپ نے بتا دیجیے
page 182 onwards.
آپ نے فائل کی ہوئی ہے
جی,
آپ نے فائل
میں نے ایکسپٹ لگائے اپنے
سی ایم اے نمبر
یہ آپ دیکھیے میرا یہ ہے 5788.
ایک سیکنڈ,
وہ کتاب پہلے کی ہے یا انٹرویو پہلے کا ہے؟
نہیں, کتاب کا نام بتائیں.
کتاب کا نام ہے جی Constitution, Law and Pakistan Affairs, written by Chief Justice Dr. Syed Naseem Hassan Shah.
یہ انٹرویو ان کا بات کا ہے یا کتاب پہلے کی ہے قصوری صاحب؟
جی,
انٹرویو بات کا ہے یا کتاب بات کی ہے؟ پہلے کون سی چیز آئی؟
I wish I could give a positive answer, but this is his written statement, and in my
انٹرویو کی ڈیٹ کیا ہے کسی کو پتا ہے؟
اس میں اندازاً after 22 minutes جو میں نے ابھی
انٹرویو کی ڈیٹ کیا ہے
کسی سر
جو چل رہا ہے انٹرویو, یہ کب کا انٹرویو ہے؟
یہ جو ہم نے دیکھا یہ کب انٹرویو لیا گیا تھا؟
سر آفٹر دی ایگزیکٹ ڈیٹ سر ابھی مجھے
3/12/2003.
یہ اس میں اس کے خط میں کیا لکھتے ہیں؟
یہ بک کب پبلش ہوئی ہے؟
یہ میرا جو ریٹن رپلائی ہے اس کے پیجز ہیں سر 42.
نہیں, یہ انٹرویو
42 سے لے کے
3/12/2003 کا. اچھا, یہ نوٹ کر لیں ڈیٹ. یہ جو انٹرویو ہے 3/12/2003 کا, ٹھیک ہے. وہ جب وہ تیار ہو جائے بتائیے. تیار ہے؟ اسی کاپی کیوں کر رہے ہیں؟ اچھا اوکے. اچھا, آپ کون سی چیز بتا رہے تھے قصوری؟
یہ پیجز ہیں.
نہیں, نمبر بتائیں پہلے اوپر. آپ کا سی ایم اے کا نمبر کیا ہے؟ یا
یہ میرا نمبر ہے جی اپنا سی ایم اے نمبر,
یہ نکالیے ذرا.
57 5788 of 2001,
5788/2001,
which I filed before this honorable court on 31st of December 2011.
جب تک وہ نکال رہے ہیں ہم یہ دیکھ لیتے ہیں.
And the extracts of the book are mentioned in my rejoinder from page 42 to page 57.
اس میں تو نہیں تو مارکس 5788 اس میں ہوگا.
ادھر دیکھیے اس بنڈل میں, اس میں تو نہیں ہے.
My lord will read this.
اس لیے میں 5788 کی بات کر رہے ہیں.
In my rejoinder from pages 42 to 57, these are all the extracts which I have collected from the book of late Chief Justice Sayyid.
تھی نا لاسٹ ٹائم کی, وہ کہاں ہے بک؟
یہ والی جس اوپن ورک.
اچھا یہ
بات سنیں
جی,
یہ یو ایس بی جو ہے
And that's very important, sir, because that will
42.
wash away all this interview, etc.
42.
42.
اس کتاب کا پہلا پیج تو میں بتا دیں نا, کس کی کتاب ہے, کون مصنف ہے, کچھ تو بتائیں نا.
مصنف اس کے جی ڈاکٹر صاحب ہیں.
پہلا پیج لگا دیا کریں نا. چلیں پیج 42 پہ کیا پڑھنا چاہ رہے ہیں پڑھیں. پڑھیے پیج 42 پہ آپ پڑھیے.
میں بڑا لمبا چوڑا ہے, میں
ریلیونٹ آپ کیا پڑھنا چاہ رہے ہیں ہمیں بتائیے نا. ریلیونٹ چیز
تو جی 42 پر لاسٹ 3 lines.
This is my view. یہاں سے پڑھنا چاہ رہے
In
ہیں.
my view, that judges do not have a crystal ball to look into the future. We must determine a matter in the circumstances submitted before us and leave to the history to judge whether correct decision was taken. See,
ایسی ریلیونٹ باتیں بتائیں نا پلیز.
آگے آ جائیے جی. میں آتا ہوں جی.
46 پیج پہ آپ نے کچھ مارکنگ کی ہوئی ہے. 186 ہے اس کا ٹائپ پیج.
یہ دیکھیں یہاں پیج, دس از پیج 56. The proposal, may I read? This is 6th line from the top. Page 56 of my rejoinder. Page, this is page, یہ کتاب کا پیج.
Mr. Kasuri, if you don't please stand here and look for the page. آپ آرام سے بیٹھیے. If the relevant page is, just tell us. Otherwise, we'll waste a lot of time just looking for what you want to read. آپ آرام سے بیٹھیے and let us know what page you want us to read.
I'll read the relevant portion, sir.
I don't want you to read the whole book. Just tell us what particular paragraph, page you want to read.
میں وہی بتا رہا ہوں جی.
بتائیے جی.
تو یہ ہے اپنا پیج 52 آف مائی پیپر بک.
جی پڑھیے, کہاں سے پڑھنا چاہ رہے ہیں.
یہ ہے 1 2 3 8th line from the bottom, 8th or 9th line.
پڑھیے.
I told Justice Dora Patel that finding Mr. Bhutto not guilty was not consistent with the thinking of the four Punjab judges since since all of them had come to the conclusion that the evidence in the High Court of the officials of the Federal Security Force who had participated in the killing proved their guilt. And these officials had no motive of their own against Ahmad Raza Kasuri. Undoubtedly, it was only the wish of Bhutto which they had carried out.
What do you want to show from this? How does this language come undoubtedly? It could be the wish of 101 other persons also. So what do you want to show us from it?
I'm coming to sir. Gradually see. That's
ज़ुबानी बता दें क्या कहना क्या चाहते हैं तो मकसद
ये है जी अपनी पेज 53 page 53 last from the bottom ninth line. While the majority judgment was written in the name of name of Inal Haq CJ, in fact it was collective effort of all the four judges who had found Mr. Bhutto to be guilty. Chief Justice had assigned various issues in the case for being dealt with by his colleague, and we had written our portions of the judgment and delivered.
लेवल प्लेइंग फील्ड केस की समाअत जारी है। केस की समाअत के दौरान चीफ जस्टिस काजी फायज ईसा ने पीटीआई के वकील से मुकालमा करते हुए कहा कि लगता है आप इंतखाबात का इल्तवा चाहते हैं। चीफ जस्टिस पाकिस्तान काजी फायज ईसा की सरबराही में 3 रुकनी बेंच ने पीटीआई की लेवल प्लेइंग फील्ड से मुतल्लिक केस की समाअत की। बेंच में जस्टिस मोहम्मद अली मजहर और जस्टिस मुसर्रत हलाली भी शामिल थे। सुप्रीम कोर्ट ने पीटीआई बल्ले के निशान का केस 10 जनवरी को समाअत के लिए मुकर्रर कर दिया और कहा कि अगर 3 रुकनी बेंच की कमेटी का मसला नहीं तो ये केस 2 दिन बाद लग जाएगा। फिलवक्त न्यूज स्टूडियो से इतना ही। मजीद खबरों और अपडेट्स के लिए देखते रहें 12 न्यूज।